Hello, good morning, good afternoon. It's noon, so I guess it's both. Welcome. I see we have people starting to join us. That's fantastic. Thank you for joining us today. We have with us today Madison Beck, who's a staff attorney with San Diego Volunteer Lawyer Program. And we also have with us Jimmie Davis Parker, a volunteer attorney with the San Diego Volunteer Lawyer Program, and they will be here to talk about rent increases and security deposits law in California. Couple quick things before we get started today. This is not a program that's offering CLE credit. If anyone is here looking for CLE credit, we are not offering CLE credit today. Basically, the State Bar looks at both the intended audience and the contact as far as what is a qualifying activity for CLE. And a program like this that's directed at the general public doesn't qualify. So that hopefully answers any questions anyone might have about that. Another thing about today's program is that it will be interactive. You can post questions if you like. We ask that you use the Q&A function that you'll see on your screen to post questions. You can do that with your name or anonymously. Just use Q&A, that icon that looks like two speech bubbles. And we'll get to as many of those as we can today. Another thing I wanted to mention is that there will be a link for a survey at the end, and we would much appreciate anyone who can take a minute or two and give feedback on the program. And then finally, one more thing before I turn it over to our speakers. This is an informational program for educational purposes today. It is not meant for individual advice. I'll let the speakers say whatever more they want to say about that, but please try to keep your questions general today rather than about your specific situations. All right, with that, I'm going to turn it over to our speakers.
Hi, everyone. Thank you for joining us. My name is Madison Beck, and I'm a staff attorney with San Diego Volunteer Lawyer Program. Today, we are presenting a webinar, Navigating Rent Increases and Security Deposits in California. With me, I have Jimmie Davis Parker, who is one of our volunteer attorneys with the Tenants' Rights Program. Jimmie is a California attorney who has represented over 75,000 tenants in several security deposit class actions, recovering $20 million in total relief at the law offices of Robinson and Markovich. We're so grateful to have Jimmie with us here and presenting with us today. I'll be doing the first half of the presentation about rent increases, and Jimmie will be doing the second half about security deposits. And then if you have questions that you put in the question and answer, I'll do my best to answer whatever I can when I'm done presenting and while Jimmie is presenting his portion. Next slide, please. So before we get started, I just wanted to go over some disclaimers. Lisa already mentioned this a little bit. This is a general legal presentation. This is not considered legal advice, but rather legal information. This presentation does not cover every single type of landlord-tenant relationship or type of tenancy. So that means the laws discussed today may or may not apply to your situation. So if you need legal advice about a specific situation going on right now, please contact an attorney. Next slide, please. What is San Diego Volunteer Lawyer Program? SDVLP is a nonprofit legal organization that provides free civil legal services to low-income individuals in the county of San Diego. Our Tenants' Rights Program specifically provides vital legal assistance to vulnerable residential tenants, and we focus on preventing eviction and encouraging housing stability. Next slide, please. So first, as I mentioned, I will be going over the basics of rent increases. Let's get started. So it's important to understand the common types of tenancies because the type of tenancy someone has can impact whether or not their rent can be increased at a certain time. So if a tenant has a fixed term lease, then that's a rental agreement for a set time period. For example, from July of 2024 to July of 2025. In that set period of time, terms of that lease cannot be changed. So that means a tenant's rent cannot be increased in the middle of a fixed term lease. At the end of the fixed term lease, things change. If a tenant has a month-to-month lease, this means there's no fixed term rental agreement, or a previous fixed term lease has expired and gone month to month. If a tenant has a month-to-month lease, then the terms can change with advance written notice. So that means if a tenant has a month-to-month lease, then the rent can be increased with proper notice. Next slide. So in California, the law that applies a rent cap is called the Tenant Protection Act of 2019. The Tenant Protection Act is also known as the TPA. The TPA states that a landlord cannot increase a tenant's rent greater than 5% plus the percentage change in the cost of living, or 10%, whichever is lower, over a 12-month period. In a little bit, I'll discuss what the current rent cap is and a little more about the change in cost of living. The TPA also indicates that a rent increase must be based on the lowest rate charged for the unit within the prior 12 months before the effective date of the increase. And it indicates that a landlord may not increase rent more than twice within a 12-month period. And that can't increase, the total increase cannot exceed 10% or whatever the rent cap is for that year. So for example, if a landlord gives like a 5% increase early on in the year, and then they want to increase a second time to make it total that 10%. When they're doing that calculation, the landlord has to go back to the lowest rate charged at the beginning of the year to calculate what the second rent increase will be so that it doesn't go over the cap. It's a little confusing. If you have questions, please enter them in the Q&A. Next slide, please. So unfortunately, not all types of tenancies are protected by the TPA. So I'm going to go through the exemptions that are written into the law. If a tenancy is exempt, that means that the law does not apply. The rent cap does not apply to that tenancy. So first, if a tenant has government subsidized or other affordable housing, like a low income housing tax credit unit, that type of housing would be exempt. This does not include Section 8 housing choice vouchers. Recently, the Attorney General announced that Section 8 housing choice vouchers are protected. So if you have a housing choice voucher, then the rent cap does apply. If a tenant has some other type of government subsidized or affordable housing, it would not apply. If a tenant lives in university or other school housing, that is an exemption. Housing that is subject to rent or price control of public entities' valid exercise of its police power would be exempted. I can't think of a specific instance that has happened. And then units that have been issued a certificate of occupancy within the past 15 years, that means newer properties. So you want to check, a tenant would want to check to see if there's a certificate of occupancy, and that type of tenancy would be exempt. And this does not include mobile homes. Next slide. A very common exemption is residential housing that can be sold separately from any other unit, so long as there is no corporate ownership and a written notice of exemption was served. So if a tenant lives in a single family home and it's owned by an individual, written notice of exemption would have to be served for the exemption to apply. If a tenant lives in a single family home where an individual is the owner and no notice of exemption is ever served, then the tenancy loses that exemption and the tenancy is protected. So that one can be a little tricky as well. And then finally, some owner shared housing is exempt. So if a tenant shares the kitchen or bathroom facilities with the landlord or otherwise lives at the same property as the landlord, that tenancy could be exempt as well. Next slide, please. So now we're at the current rent increase cap. So for covered tenancies, the current rent increase cap is 8.6% from August 1st, 2024 to July 31st, 2025. Now, this is because the calculation that I mentioned earlier, once it's done, that number comes out to lower than 10%. So the percentage change in the cost of living for the applicable period is 3.6%. When we add that to 5%, we get that 8.6% number, and that's lower than 10%. So lucky for all tenants, the rent cap that it applies to, the rent cap is a bit lower than last year at 8.6%. We get these numbers from the Bureau of Labor Statistics, the cost of living for the applicable period, and then that's how we figure out the calculation. Next slide, please. As I mentioned earlier, a notice must be served in order to change the terms of a tenancy, or in this case, to increase rent. So rent can be increased during a month-to-month tenancy or at the end of a fixed-term lease. In order to properly serve the rent increase notice, a landlord must either personally deliver the notice to the tenant by hand, or they can serve it via mail. If the landlord chooses to serve a rent increase notice via the mail, then additional time for the notice must be given, and that's required by the law. Next slide, please. And another important thing to note is the length of the rent increase notice. If the proposed rent is 10% or less, the increase, then the notice given must be 30 days prior to the effective date of the increase. If the increase is greater than 10%, so possibly for tenancies that are not protected by the TPA, then the notice given must be 90 days prior to the effective date of the increase. Next slide. So that wraps up the rent increase portion. If you have questions about anything regarding rent increases, please pop it into the Q&A and I will answer what I can. Now I'm going to pass things over to Jimmie, who will be presenting about security deposits.
Thank you so much, Madison. My name is Jimmie Parker. Good afternoon, everyone. As was briefly mentioned, I'm a 17-year attorney. I have been a litigator that entire time, and I have several security deposit focused class actions as a part of my practice. We can go to the next slide. All right, security deposits. Security deposit is a refundable payment that a landlord generally requires a tenant to pay upon moving into the unit. It's important to know about security deposits is that they're limited in the amount that a landlord can charge. Generally speaking, it's 1 month's rent. However, there are some exceptions, kind of what Madison was talking about with respect to the rent increase exceptions that also apply to security deposits. However, even in those circumstances, the maximum they can charge you for a security deposit is about 2 months. A security deposit is any payment you make at the beginning of, typically at the beginning of the leasehold, that is separate from and apart from any monthly rent you're paying and any application screening fee. If there's sometimes landlords will have, like, for instance, say a pet deposit. Whether it's a pet deposit or a security deposit, a pet deposit still falls into the protection of California security deposit statutes. It's considered a security deposit irrespective of how it's described, if it's described as a pet deposit. One thing that is important to know is that no aspect of a security deposit can be deemed non-refundable by operation of the lease. Next slide, please. Security deposits can only be used by for purposes that are laid out by statute. So a security deposit can only be used by a landlord to either make them whole on rent in arrears. That means rent that you have not paid but has been due, to repair any damages to the unit beyond normal wear and tear, and to make the unit as clean as it was when you accepted the tenancy. There's also one more thing. If it was a furnished unit, if you're renting a furnished unit, a security deposit may be used to clean or repair furnishings that the landlord had in the unit. Aside from that, the law is fairly clear A security deposit cannot be used to pay like a lease break fee or rent that may be due in the future, or even utilities. Utilities should be billed separately. A security deposit must be used only for unpaid rent, for repair beyond wear and tear, and to bring the unit as clean as it was when you accepted the tenancy. Next slide. So explicitly, we went over what a landlord can use a security deposit for. They can't use it for anything else. Frequently, landlords may try to deduct and retain from a security deposit for damage that existed in the unit before the tenancy began. The landlord is not legally able to do that. They also must not use it for anything that's unreasonable or unnecessary, or be anything that's beyond normal wear and tear. Next slide. And real briefly with wear and tear is kind of a reasonableness standard. It means how much wear and tear is to be expected in a unit on just normal living for a period of time. And what we have in our industry, so to speak, is that there's usually lifespans given to things like paint and carpet. So if you're in a unit for 3 years, that's about what you would expect the lifespan to be on the paint. So any amount that you had lived in the unit up to about 3 years, your security deposit deduction for replacing paint or repainting the unit should be deducted on a pro rata basis, meaning if you lived there for 2 years and the lifespan on the paint was 3 years, and the paint had to be refreshed, or the unit had to be repainted, you would only be legally responsible for 1/3 of the cost of that paint. Okay, and the same thing goes for carpet. If the carpet has to be replaced, there's typically a lifespan in the industry of 7 years for a carpet. If you lived in the unit for 6 years and the carpet was brand new when you moved in, and they had to replace it upon your departure at the end of the 6th year, you are only legally responsible for 1/7 of that replacement cost, because they cannot charge you for wear and tear. And that's how wear and tear is typically calculated. Okay, very important. When you move out of a unit, when you move out of a leasehold, the landlord has 21 days to do several things. Number one, they must either provide you with an itemized statement, including the basis for and the reason for every deduction against your security deposit. If the landlord used outside vendors to repair or clean the unit, they must provide within 21 days of your departure copies of the actual vendor invoices and receipts that they received for performing the work on the vacated leasehold. So for example, if you moved out of a unit and they deducted your security deposit for painting, and they said on the itemized statement, Bill's Painting Company painted this unit and it cost us $300, and that's why we're retaining $300 from security deposit. They also must include the invoice directly from Bill's Painting for $300 or whatever it ended up charging, to evidence that they are not, to evidence the fact that they actually did the work at the cost that they're alleging it was performed. If they allege that the work was performed by an in-house employee, for instance, if they said, we painted the unit, but we used our own maintenance workers to paint the unit, they're required then to provide the hours spent working and the hourly rate charge for that maintenance worker to paint the unit. If they do not have those items disclosed to you, then they're not permitted under the law to deduct from it. And that's a 21-day time frame. There is one minor exception that usually doesn't apply. However, if they're not able to get the invoices for whatever reason from the vendors that perform the work within 21 days, they're allowed to provide you a good faith estimate with their deduction and itemized statement. However, nonetheless, within 14 days after receiving the invoice from the vendor, they're required to provide it to you. So irrespective of when they receive it, you should always be seeing evidence that they actually performed the work on the leasehold to substantiate any deductions they made from your security deposit. And it is true that the law in California, the case law in California under Granberry versus Islay Investments, is that if a landlord fails to return the security deposit within 21 days or perform any of the with respect to the disclosures within 21 days, that they have lost the right to self-help from the security deposit, and the entire security deposit should be refunded to the former tenant. Now, that does not automatically mean that you can't get sued in small claims court to repair or replace something if they didn't comply with the law within the 21 days. However, it means that they don't just get to keep it from your security deposit. Next slide, please. All right. So what to do when you're having a dispute with your landlord over your security deposit. And I think that we get into kind of the best practices maybe in a later slide, but you give your notice. Ideally, you're giving notice within 30 days or whatever the time frame is provided for in your lease when you're going to be vacating the unit. After notice is given, the landlord is required to provide a 2-week window for them to do a pre-move out inspection. The purpose of the pre-move out inspection is to apprise the tenant of any issues that the landlord sees that will need to be remedied or deducted from a security deposit prior to your departure. It gives the tenant an opportunity to fix those issues themselves prior to the deficiency being deducted from a security deposit. At all times when you're dealing with a landlord and you're dealing with the condition of a unit, a lot of these disputes turn into who has the best evidence, right? And the best evidence for tenants are photos and videos of the condition of the unit when you moved out, the empty unit when you moved out. Photos and videos of the empty unit when you moved out will typically provide the best evidence you can have in a dispute over whether or not something needed to be replaced or the wall needed to be repainted, so forth and so on. It is important to memorialize conversations you have with the landlord about your security deposit. What I mean by that is try to do everything in writing, whether it's a written letter or an email. Try to do that all in writing so you have a record of what was said. If by chance there is an interaction that's not recorded that you have verbally with a landlord or their agent, it is always a good practice to go ahead and email that landlord after the interaction, reiterating what occurred and what was said and what the next steps were, because that would be a contemporaneous writing evidencing that that conversation took place. And that's typically have a good evidentiary value in these type of disputes. So please make sure to memorialize all your communications with the landlord. The first step typically in a dispute is to write a letter to the landlord. The security deposit statute that we mostly rely on is California Civil Code section 1950.5. And when you write a letter to the landlord disputing that either you didn't get your security deposit returned, you didn't get any paperwork with it, or the paperwork they sent you was deficient, or you otherwise disagree with it, go ahead, put everything you can in that letter. Make sure you have an electronic copy and send it off. And that's usually the first step towards working towards resolution of a security deposit dispute. If you're unable to work it out with them via letter, you are entitled to go to small claims court. Unfortunately, there's no lawyers allowed in small claims court, so you would be on your own. However, you should be well equipped with knowledge gained from this presentation and also any research you do on section 1950.5 on what a landlord is entitled to deduct for and what paper they're required to provide if they violate any of those aspects of security deposit administration, either charging you for things that they're not allowed to, or they did not give the proper paperwork. You may sue them for the amount of the security deposit retained. And if it's found to be done in bad faith, which is a bit of a higher standard, the judge has the opportunity to award you twice the amount of security deposit retained, typically referred to as treble damages. And next slide. And we've kind of talked about this. 21 days after the tenant vacates, a landlord is required to return the security deposit or any remaining funds to the tenant and provide the tenant with an itemized statement indicating the basis for and any amount of deductions. The landlord may be required to include the time spent in hourly rate charge or provide copies of invoices and receipts. So they definitely do have to do one or the other. So within 14 days of receiving an invoice, they have to provide you with the evidence that the work was performed, and they also have to give you the hourly rate charge and time spent if they used an in-house maintenance worker to perform the work. And if they fail to do that, they're at risk for losing their the opportunity to deduct from the security deposit, and you should get a full refund. Next slide, please. I think we went back. There we go. Okay. Yes, how to protect your deposit at move-in. Prior to moving in, inspect the unit with your landlord and make a list of damages, or if the unit's uncleanly, make note of that. And frequently what happens is that they will do a pre-move-in inspection with you, and you've probably seen the list, seen the sheets that apartment complexes typically use, where they will list various appliances or rooms, and they'll mark dirty, not dirty, clean, needs work, what have you. It's critical for you when at the end of that inspection, that if you don't agree with something that they wrote on their list, to go ahead and make a notation that you disagree with it, and that and make whatever observation you want about it, and then sign it. You don't have to sign exactly what they'll give you. And again, the best evidence for this is photographs and videos of the entire unit. Make sure you keep them electronically stored somewhere, or on your phone, or wherever you know you might need them, in case there is a future dispute over your security deposit. Again, try to keep all your communications in writing, and memorialize communications via email if they are done verbally. Ideally, you want to stay the entirety of the lease to avoid any opportunity for a lease break fee or anything along those lines. Even though it's not really part of our presentation today, a landlord should not be charging lease break fees that are egregious. Sometimes I see rental concessions where someone leaves a month early and they want to charge, $15,000, $16,000. That's unreasonable under the law, and that's another topic. We could do another presentation on that, but ideally you want to stay for the entirety of the lease. Next slide. All right, and if you want to get your deposit at Move Out Back, the best practices is you want to clean the unit and restore it to the condition it was when you moved in, right? You can request the inspection of the unit, and the landlord is obligated to give it to you with the landlord or the landlord's agent. And again, as I discussed earlier, it's an opportunity for the landlord to notice any deficiencies in the unit that they think they'll need to address out of your security deposit. And it also is an opportunity for you to either fix what needs to be fixed or clean what needs to be cleaned without it being deducted from your security deposits. The inspections must take place no earlier than 2 weeks prior to your moving out of the unit. That is true under the law, usually at an reasonably agreed upon time, to conduct that inspection, pre-move out inspection. And again, like a broken record, take photographs and videos and keep them in a safe spot. Next slide. All right, I think that's it for me, and I'll pass it back on to Madison, and I look forward to any questions. Thank you.
There's a question, Jimmie, that I don't know the answer to, and I'm hoping that you might. But great job, Jimmie. Thank you so much. Everything was so well explained. Thank you. So as for some legal assistance, we like to put some resources in our presentations in the event that anyone needs legal help and might be able to get assistance from us. So our tenants' rights program can assist with the following issues that are listed on the slide. If you have a 30, 60, or 90-day notice to terminate your tenancy, if you've received a rent increase, or if you need help with a reasonable accommodation request, if you dispute your security deposit, or have a buyout agreement issue and you live in the city of San Diego. These are all things that our program might be able to help you with if you qualify for our services. You could call this number, but preferably apply online at sdvlp.org, because when you call, you will be instructed to please apply online. And the next slide, please. We just have one more slide with some other legal resources. In the event you might have a legal issue we cannot assist you with. Legal Aid Society of San Diego also has general housing programs, and their numbers listed there. I do believe for Legal Aid Society of San Diego, you have to call. And then if you happen to have received a summons and complaint for an unlawful detainer, meaning a lawsuit has been filed against you for an eviction, the Legal Aid Society of San Diego has an unlawful detainer self-help clinic where you can get assistance filing your response, also called an answer. And that's at the Hall of Justice downtown, right next to the courthouse. And they're open Monday through Friday, 8:30 to 3:30. It is a walk-in clinic. It is first come, first serve. So get there early if you need their help. And then also USD School of Law, the Housing Rights Project assists low-income undocumented tenants, and their phone number is there. Jimmie, do you maybe have an answer to the question?
And
Yes, I do. Yeah, it's a great question. So the question was asked, what if a lease has a mediation clause and the landlord wants mediation, but the tenant wants to sue in small claims court? All right, so whether or not a landlord can force someone to go to mediation prior to going to small claims court by virtue of their lease is an open question in the law, whether or not that has any teeth to it. Sometimes you see in leases that they'll say, well, if you refuse to go to mediation first before you go to small claims court, then you cannot recover attorney's fees or costs. I've seen leases like that. So number one, there's not a good solid legal answer to the question. However, practically speaking, I would always encourage both sides to at least attempt mediated resolution, because it's typically faster and than going into small claims court and then expending the resources and time and energy to do that, to get a judge who may rule against you. You could lose at court. And one last thing, if you go to mediation and you really want to go to small claims court and you don't think they're going to give you what you're going to want, what you think is fair, it's okay. There's no harm into attempting mediation and sticking to your gun, so to speak, and digging your heels in and saying, no, I want my entire security deposit back because XYZ. And if the landlord doesn't agree, mediation fails, you haven't lost anything, go right to small claims court. So in that situation, I would at least be open to it. There's low cost mediators available. And if it doesn't work out there, then go ahead and sue.
Awesome. Thank you, Jimmie.
I'll just add a couple of things while we're waiting to see if anyone else has questions. And please, folks, you've got a great resource here. If you have any, be sure to ask. We've got plenty of time. So with San Diego Law Library, we also have resources that can help you if you're looking for landlord-tenant law information. We have books that are do-it-yourself law books written for the general public, including tenants' rights, landlords' rights and responsibilities, eviction defense. So please come on in and see us if you are looking for information or want to do some research. We have a database called Gale Legal Forms for California that has some great sample letters. If you're looking for samples of letters to send the landlord along the lines of what Jimmie was talking about, or anything related to that. We also have information on our website. So take a look at our website at San Diego Law Library, all one word, .org, San Diego Law Library.org. We've got a self-help information section that includes landlord-tenant information. We have a list of legal clinics that are out there on different topics in our area under self-help. And we also have some guides and samples. And you will find, if you're looking at that information, you will also see again, this contact information for legal aid and San Diego Volunteer Lawyer Program. You can also find that if you're looking for it again on our website. And then finally, one more thing, since I don't see a question yet. We will be posting this recording and the slides on our YouTube channel, on the San Diego Law Library YouTube channel. If you're looking for it, it should be there within a few business days. And you can find the link to our YouTube channel on the homepage of our website, or you can just search YouTube for San Diego Law Library and you should find our YouTube channel, where you will also find other helpful recordings on many, many topics. So give it another minute or so, and if no one has questions, we'll go ahead and wrap up. Anything else that you can think of that you want to add, Madison or Jimmie?
Not me. Jimmie, do you have anything to add?
No, I think we touched everything I'd want to talk
I
about.
guess I did write down that SDVLP does have our North County Unlawful Detainer Clinic, and landlords can get legal information there. And that's at the North County Courthouse up in Vista.
And if you're looking for information about that, again, you can look at the San Diego Volunteer Lawyer website or the San Diego Law Library website. We do have that listed in our list of clinics.
All right, we got it.
So Jimmie, do you have any class action lawsuits going on now that our patrons might be able to participate in?
It's possible. So I have active matters against Essex Property Trust and Graystar. If you're a tenant or former tenant of either one of those companies, you can reach out to me directly at jdparker@gmail.com, and we'd be interested in hearing from you. It looks like we got a question. This question is, are there any laws about appliances like microwaves that are broken by the tenant if the lease does not address appliances? So this is an instance where that would be a furnishing provided by the landlord. Wear and tear would apply. So depending on the age of the microwave oven, you would be responsible, and embedded in the question is that the tenant broke it. The landlord would be able to deduct from a security deposit the cost of replacement of the microwave oven less the lifespan of that oven, right? So I don't happen to know the agreed upon lifespan of microwave ovens, but you could probably do a Google search of the appliance type and enter in lifespan, and it will give you an idea. Maybe it's 5-10 years. Who knows? I have no idea. But you would not be responsible for the full cost of replacement. You would be responsible for what was left on the lifespan of replacing that microwave oven.
So if it was a brand new microwave, then you might have to pay it all. Could you replace the microwave, Jimmie, or do you have to wait for the deduction?
So I wouldn't replace the microwave. I would educate myself on the cost of replacement, and they would not be allowed to charge anything beyond what's reasonable. So if you know what it's going to cost to replace this microwave oven, and they charge an exorbitant amount to do so, they would be in violation of the law for charging an unreasonable amount.
Okay.
But I would just arm myself with what does it cost to replace this microwave oven? How long has it been there? And then figure out a fair amount to pay for the replacement, less what was used on the lifespan of the oven. And I would make those requests in writing too. So if you're dealing with the landlord, just request non-confrontationally in an email, can you please let me know what year this microwave oven was installed? I would like to do some research on what it would cost to replace.
Great answer.
All right, well, going once, going twice. I don't see any other questions pending. I think we'll go ahead and wrap up. It sounds like everyone's already had their questions answered today. Thank you both so much for all the information. Again, this will be available on our YouTube channel sometime in the next few days. So be looking out for that if you want to review any of this information. And thank you so much, everyone, for joining us today. And thank you so much to our speakers.
Thank you. Thank you, Lisa, for having us. We love partnering with the San Diego Law Library, and hopefully we'll be able to work out another presentation again soon.
And likewise, we definitely value our partnership with you as well.
Yes.
Bye,
Thank you so much.
everybody.
Thank you.
Thank you, Madison.